Hello, hello, hello. As most of you know, I'm Dana Malone. I am a cannabis paralegal at Brady and Associates. I primarily do cannabis law, and I have been working on the statutes and other things to help keep you compliant. So, what's on the topic list today? It's OBNDD, Oklahoma Bureau of Narcotics and Dangerous Drugs, has been granted a fee increase by our amazing, she says sarcastically, Oklahoma state legislatures, and our even more wonderful governor for allowing this to go through without his signature. Again, sarcastically. I try to keep my opinions out, but there's a couple of these that just, my opinions are going to come through. I'm not going to state my opinions, but you're going to know I'm not thrilled with either at this moment. The wonderful Oklahoma State Legislature, in their infinite wisdom, wrote Senate Bill 15X. And in it, it grants OBNDD a fee increase. And we're not talking just a little fee increase. We're talking 3 times what it was. Well, could say 4. Anyway, it's $2,500 plus convenience fee. But there's some other language in here that people are not focusing on. And you need to be aware of this. I'm just going to read it, and you can do with it as you may. This is, as I said, Senate Bill 15X, and it is an act relating to the Uniform Controlled Dangerous Substance Act, amending 63 OS 2021, Section 2-303, which relates to the registration and regulation of manufacture, distribution, dispensing, prescribing, administering, and using for scientific purposes of controlled dangerous substances, increasing certain registration fees, updating statutory reference, and declaring an emergency. The big bad medical marijuana industry, we're causing an emergency. So anyway, the director of the Oklahoma State Bureau of Narcotics and Dangerous Drugs Control shall register an applicant to own a medical facility as described in subsection C of Section 2-302 of this title, or to manufacture, distribute, dispense, prescribe, administer, or use for scientific purposes controlled dangerous substances included in Schedules 1 through 5 of Section 2-101 of this title, unless the director determines that the issuance of such registration is inconsistent with the public interest. Keep that in mind, guys. In determining the public interest, the following factors shall be considered. 1. Maintenance of effective controls against diversion of particular controlled dangerous substances of any Schedule 1 or 2 substance compounded therefrom into other than legitimate medical, scientific, or industrial channels, including examination of the fitness of his or her employees or agents to handle dangerous substances. To me, that sounds like a bunch of mumbo jumbo, but it's not. Number 2 is compliance with applicable state and local law. Number 3, has been found guilty of, entered a plea of guilty or nolo contendere to a charge under the Uniform Controlled Dangerous Substances Act or any other state or federal law relating to any substance defined herein as a controlled dangerous substance or any felony under the laws of any state of the United States. Remember that. I'm going to read this again. Number 3. Now remember, this is where the director of the Oklahoma State Bureau of Narcotics and Dangerous Drugs can determine whether you get a license or not. Has been found guilty of, entered a plea of guilty or nolo contendere to a charge under the Uniform Controlled Dangerous Substances Act or any other state or federal law relating to any substance defined herein as a controlled dangerous substance or any felony under the laws of any state of the United States. This is totally different than what we have been living by. These are not the same words, and it's not what 788 was about. I'm going to leave it at that. Furnishing by the applicant, number 4, furnishing by the applicant false or fraudulent material information in any application filed under Section 2-101 of this title. Number 5, past experience in the manufacture, distribution, dispensing, prescribing, administering, or use for scientific purposes of controlled dangerous substances, and the existence and the establishment of effective controls against diversion. Number 6, denial, suspension, or revocation of the applicant's federal registration to manufacture, distribute, or dispense controlled dangerous substances as authorized by federal law. This does not have to do with this particular one. Number 6 does not have to do with us because we're not federal. Number 7, such other factors as may be relevant to and consistent with the public health and safety. This is big because basically they can, just like OMMA, they can call anything. It's a public health and safety risk. So beware. Nothing herein shall be deemed to require individual licensed pharmacists to register under the provisions of the Uniform Controlled Dangerous Substance Act. B. Okay, that first part I read at the beginning was A. Registration granted under subsection A of this section shall not entitle a registrant to manufacture, distribute, dispense, prescribe, administer, or use for scientific purposes controlled dangerous substances in Schedule 1 or 2 other than those specified in the registration. Okay, now C is basically for doctors. Okay, D, the director shall initially permit persons to register who own or operate any establishment engaged in the manufacture, distribution, dispensing, prescribing, administering, or use for scientific purposes of any controlled dangerous substance prior to June 4th, 1991, and who are registered or licensed by the state. Fees for registration under this section shall be as follows. Okay, guys. So I'm not going to deal with doctors and pharmacies and stuff like that. So we're going to go straight down here. Medical facility owners, actually, the grows and the processing, those are called manufacturers as far as the state is concerned. So they're going from $500 annually to $2,500 annually. The dispensaries, they're going to stay at $300 annually. So that's big. $2,500 plus a convenience fee. Don't forget, the state charges convenience fees because, you know, they do. But here's some additional information that you must know. A registrant shall be required to pay double the amount of the above listed fee for any renewal of registration received more than 30 days late. All right, you have to have your renewal done by October 31st. That's a drop dead date. However, they're saying if you register 31 days late, which would be December 1st or later, you're going to pay $5,000. If you are if you're a manufacturer, if you are a grow or a processing, you're going to pay $5,000 for that registration, that renewal. And you'll pay the convenience fee as well. So, it states in here a $10 fee shall be charged for a duplicate registration certificate. We get those online. You get them out of your portal. So I don't know what that's about unless they're going to change that. Who knows? Any way to get $1, I guess. Compliance by manufacturers and distributors with the provisions of the Federal Controlled Substance Act 21 U.S.C. Section 801 respecting registration, excluding fees, shall be deemed sufficient to qualify for registration under this section. Under Section 2-101 of this title. And then here's Section 2, it being immediately necessary for the preservation of the public peace, health, or safety. An emergency is hereby declared to exist by reason whereof this act shall take effect and be in full force from and after its passage. All this did, it changed a little bit about backgrounds, but all this did was increase your fees. So how does that make this an emergency? How do backgrounds make this an emergency? You have to have a background check before you get the OMMA license. I know that OBNDD does nationwide background checks, but how does this declare an emergency? Out of all the years I've been doing this, I've only had 2 come back that couldn't pass the background check, the nationwide background check. And I've done thousands. Well, we'll say more than 1,000. So, needless to say, I'm not seeing where this emergency exists. Now, I do want you to know, if you don't get your OBNDD, the supplemental packet done, if you do not submit the stuff for the fire marshal, showing that you've submitted for your COO, they will deny your application and you will have to pay all over again. It's not like OMMA where you get to fix it if it's rejected. They do not reject, they deny. And if you don't follow their procedures, say you submit your supplemental packet because there's been an ownership change and you had to apply for a new one. You submit your ownership packet. They found something insufficient in the packet. They will email you, and they will give you 7 days to cure the issue, correct the issue. And if you don't have that in there on the 7th day, your application will be denied. And denied means just that. It's done, it's over. You have to file for a new one. All the money you've spent is gone. So let's not give them additional funding. It's bad enough that they increased the fee by this much. I mean, I just don't see it, but that's me. Since they don't communicate with us and don't tell us what their needs are and don't give us answers when we call, they literally just do not communicate. So I think the world of most of the people that work at OBNDD, but unfortunately, the ones that we talk to, they don't know, because nobody in the organization that is higher up is disseminating the information down to them. So I love my ladies at OBNDD. Everyone I've talked to, just amazing. But their hands are tied. So always, if you call in there, be kind. I don't know that OBNDD knows what the hell they're doing. I'm talking about the director on down to their legal people. I don't know, because we're not getting any answers. We're not getting any callbacks. And I've tried. I have tried, and I've given up at this point. So what's coming up? So I have been in contact with the DEQ, and I'm going to be working with them. I've also been in contact with the Oklahoma Water Resource Board. I got a little bit of research to do, and then I will do a video on that. I'm waiting on a call back from the DEQ and to get more additional information. But anyway, as always, it's great to be with you today. I'm Dana Malone. I'm the Oklahoma Cannabis Paralegal, your Oklahoma Cannabis Paralegal. And I am with Bridie and Associates. And if you've got questions, you can post them wherever you're seeing this video and I will respond. Or you can call our office at 918-900-0470 and I'll be more than happy to talk to you. Have a wonderful and a blessed day. Bye.